I was there to help people, not hurt people. I had a legal right to, one, possess it, and two, possess it concealed.
One of the questions that has arisen concerns Gaige Grosskreutz. Apparently he has a felony conviction from the past. In fact, one of my other videos showed that such is the case. And his felony conviction was expunged by the state later. Now, I'm not sure what was involved in getting his felony conviction expunged, but whatever the case, it was expunged. And now the question becomes, well, could he then possess a firearm? He had a firearm that night, and the question, does that break the law? Now, originally, my feeling was no. Expunging a felony means that the felony no longer applies, and he's no longer considered a convicted felon, and therefore he can possess a firearm. Not so fast. It turns out that my understanding was mistaken. Whether or not an expungement allows a person to possess a firearm varies from state to state, and I made an assumption about Wisconsin that I should have explored further. Hello out there. I'm trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, so let's take a look at section 941.29. This is the relevant section, possession of a firearm. Now I'm going to go ahead and skip over down to section 1M, which states, a person who possesses a firearm is guilty of a Class G felony if any of the following applies. Now, the only one that we're going to be concerned with is Part A, which says the person has been convicted of a felony in this state. The other sections don't really pertain to what we're interested in here. Nothing here is particularly important until we get to Section 5. Section 5, this section, which is Section 941.29, does not apply to any person specified in subsection 1M, which is what we read, who A, has received a pardon with respect to the crime or felony specified in subsection 1M or 4M, and has been expressly authorized to possess a firearm under 18 U.S.C. APP, I think it must stand for appendix maybe, 1203. I'm not a lawyer, so I don't want to hear it. Or has obtained relief from disabilities. Well, we don't have to worry about the disabilities. That concerns whether he was mentally unfit or something like that. What concerns us is 5A, and it says here, Gaige Grosskreutz, what we see, cannot possess a firearm unless he has been pardoned by the governor. At first, I thought, all right, cut and dry. Not so fast. I want to make sure that there is not some other prohibitions in here that I skipped. So I looked at the other sections and I read them carefully, and these other sections do not apply. But then you come down and you have to read the little footnotes at the bottom. You can never tell. You don't want to jump on things too soon. Okay, so these footnotes are not really particularly interesting until we get to the ban on felons possessing firearms is constitutional, and that ban extends to all felons, including non-violent ones. I totally disagree with this. The governmental objective of public safety is an important one. and the legislature's decision to deprive a non-violent felon of the right to possess a firearm is substantially related to this goal. So it doesn't matter whether or not Gaige Grosskreutz committed a violent felony or not. I completely disagree with this, by the way. I think that if a person has been convicted of a felony, tax evasion, I cannot understand how allowing that person to have a firearm is somehow endangering the public. To me, this is overreach, and it deprives people who should have the right to bear arms from having one. And no, I'm not a felon, so I don't want to hear it. Also interesting here, attempted possession of a firearm by a felon is a crime recognized under Wisconsin state law. Well, let's see. Joseph Rosenbaum is a convicted felon, and he tried to take Kyle Rittenhouse's firearm from him. So in this case, strict reading of the statutes here, Joseph Rosenbaum's attempt to take Kyle's gun itself was a crime, which is rather interesting because a lot of people say, well, you cannot claim self-defense if you're committing a crime at the time. Well, in that case there, Joseph Rosenbaum would have been committing a crime and therefore could not have claimed self-defense from Kyle's decision to shoot him. Really interesting how this kind of works. Okay, so going up a little bit, the restoration of a felon's rights in Virginia is not a pardon for the purposes. So in this case here, when they were reading it, the person had his right to own a firearm restored to him and was claiming that that was a pardon. It's saying it is not. And subsection 5A, which again, it goes back to the fact that you have to have a pardon to be allowed to possess a firearm, and that expungement is not enough, has been invalidated by congressional action. Pardons granted after November 15th, 1986 will give recipients the right to receive, possess, or transport in commerce firearms unless the pardon expressly provides otherwise. So in other words, the congressional action, the U.S. Congress enacted legislation that loosened the prohibition on firearm ownership, which is going to be of some interest here in a moment. All right, let's see what some of the others are saying about this. I figured that, look, if expungement of a crime is tantamount to having your gun rights restored, that would be really important. There would be a lot of people wanting to get their gun rights restored if they have been convicted of felony but had their felonies expunged. Therefore, there should be no trouble finding experts on this issue willing to talk about it. So let's take a look and see what others are saying. Okay, so this is a law office that's based in Wisconsin. And this statement down here says, Wisconsin's firearm laws prohibit the following people from having a gun. And the first one, people who are convicted of a felony. Now, it goes on to say, if you wish to receive a governor's pardon, which is not the same as an expungement, to restore your gun rights, Wisconsin's Pardon Advisory Board allows people who completed their sentence 5 years ago, have no intervening convictions, and no pending charges apply to restore their gun rights. Okay, so they're saying that you may be eligible for a pardon if you want to get your gun rights restored. And we won't worry about what requirements are because I'm pretty sure that Gaige Grosskreutz has not been pardoned. Now, here's what's important. Going back, this is a Wisconsin criminal defense attorney, and they have a page on what you have to do to get your gun rights restored. And they do not mention anything about an expungement allowing you to get your gun rights restored. In fact, they're essentially saying you have to have a pardon. And one thing that comes out of it here is, one, they're from Wisconsin. Two, they should know the law in this regard. So if there was a possibility to have your gun rights restored, then I'm sure they would have mentioned it. Now let's take a look here. This is a restoration of rights project. This is national, but their focus is on restoring your rights. And therefore, and they do have something here on Wisconsin. And if you could if you could restore your gun rights through expungement, I'm sure they would know about it. But when you go down here, it says here, firearms. A person convicted of a felony may not possess a firearm. And it refers to 941.29. Firearm rights are restored only by a governor's pardon. The case strengthens. Let's move on. One more. Well, actually, a few more. And this is from the Wisconsin Department of Justice. Now, they should know. And so we come down here. What are the Wisconsin statutes related to firearms? Okay, and so they mention convicted of a felony in this state. And we go down. This is the Wisconsin Expungement Program. Their focus is on felony expungements. Wisconsin, and they're devoted to expungements. They should definitely know whether having your record expunged would allow you to have a firearm. And you go down and it says here, the right to bear arms. Does a convicted felon have a right to bear arms? Under both Wisconsin and federal laws, a convicted felon is forever prohibited from carrying or possessing a firearm. Now they have a question mark there, but it's clearly a typo. Now, let's take a look at another interesting court case that came up that really, I think, settles it. Let's go to Court of Appeals. This is Moran versus the Wisconsin Department of Justice. And what do they say? To further explain, both Congress and the state of Wisconsin have made it a crime, generally speaking, for a felon to possess a firearm. As discussed above, the federal statute excludes a greater number of individuals from the scope of the general prohibition than does the Wisconsin statute. In other words, the federal government is more lenient. Wisconsin is stricter in only allowing those who have been pardoned from being able to possess a firearm. By enacting 18 U.S.C., Congress decided that felons who have been relieved of all of the consequences of their criminal conduct, in whole or in part, by expunction, which is expungement, pardon, or restoration of civil rights, may lawfully possess a firearm under federal law, and consequently may not be prosecuted for a violation of 18 U.S.C. Now keep in mind, these are the feds, and so Wisconsin is not necessarily bound by this. So the idea is this. It could be that Wisconsin has this very strict requirement that to be able to possess a firearm, you must be pardoned for the crime. And that was based on earlier U.S. code. However, the law changed in Congress. And the argument could be made, well, since the Wisconsin law was based on U.S. law and the U.S. law has changed, that would allow me to assume that the Wisconsin law has changed accordingly. The reason why they say this is because when the Congress changes its laws, there comes a time, there's a delay in what the states can do in response. And therefore, because it takes time for the state to respond to those changes, then one could assume under certain circumstances that the law change made by Congress also applies at the state level. However, it says here, our state legislature has not reached a similar conclusion with respect to the exception contained in Wisconsin Statute 941.29, which conditions the lawful possession of firearms in the felon having received a pardon only. The repeal of 18 U.S.C. 1203 and the enactment of 18 U.S.C. 941A20 occurred over 3 decades ago. There has been ample time for the Wisconsin legislature to respond to the changes to the federal felon in possession statutes by adopting the less restrictive federal standard if it wished to do so. Yet it has not so acted. Under these circumstances, we must give effect to the plain language of 941.29, which stated what? You must have a pardon, not an expungement, at least to the greatest extent possible, given the repeal of the specific federal statute cited within it. So in other words, yes, it is true that if Congress changes a law that your state has based its law on, that you could say that the state's law changes accordingly. And that is because there's this delay in the time in which the state can enact the changes made by Congress. However, according to them, this occurred 3 decades ago. If Wisconsin really wanted to loosen its treatment of felons in this regard, it would have done so. It did not. It has decided to maintain the law that says that if you want to have your right to own a firearm restored, you must get a governor's pardon. Okay, so I want to go back and take a look at what this whole court case was about. We go ahead and read down here. So Moran was convicted of a felony in Virginia. He moved to Wisconsin, and the Virginia courts granted Moran's petition to own a firearm because his ability to own the firearm differed between when he was in Virginia and when he was in Wisconsin. It says, Moran raises numerous arguments challenging the Department of Justice's determination. He contends the DOJ improperly interpreted 941.29. In other words, Wisconsin has this law that says you have to have a governor's pardon, and the DOJ misinterpreted it, which identifies 2 circumstances under which a felon can lawfully possess a firearm in this state. And of course, they're talking about Wisconsin. We agree with the DOJ that under the plain language of subsection 5, a felon must either have received a pardon with respect to his or her crime, see subsection 5A, or have obtained relief from his or her disabilities, and we're not going to worry about that. Moran has satisfied neither of these conditions. We reject Moran's assertions that 941.29.5 has been preempted by federal legislation, and that the restoration of his right to possess a firearm in Virginia is the equivalent of a pardon for purposes of Wisconsin law. They're making it very clear here. There's no doubt about it. Congress's decision to change the law does not preempt Wisconsin's law, and Wisconsin's law is very clear on this point that to possess a firearm, you must have received a governor's pardon. I'm not a lawyer, and keep in mind, a lawyer might be able to come along here and point out something I did wrong, but keep in mind, I looked at other websites from Wisconsin legal teams who specialize in this, and even they say that for a felon to be able to possess a firearm, he or she must have received a governor's pardon. Like my video, subscribe to my channel. I'm working hard to figure this all out.